The 1967 Arizona Consumer Fraud Protection Act, ARS Air 44-1522, was enacted to protect the public from deceptive or unfair business practices, including those in real estate transactions. It prohibits any act, omission, misrepresentation, or concealment intended to deceive or mislead consumers in connection with the sale or advertisement of real estate. Real estate professionals must ensure that all advertising, disclosures, and statements are truthful and not misleading, as violations can result in serious legal and financial penalties. Under ARS PRO 34-1521, the Act applies to real estate activities by defining key terms such as merchandise to include real property and services. This means that any deceptive activity involving property sales, leasing, or promotion is subject to the same consumer protection standards as other goods and services in Arizona. If a licensee or company is found guilty of fraud under ARS PRO 44-1531, the court may impose civil penalties, restitution to affected consumers, and injunctions to stop further violations. The Attorney General has the power to investigate complaints and enforce the Act, making consumer protection an active and enforceable part of real estate law. The Homestead Laws, ARS, PBRCARS 33-1101 through 33-1105, protect Arizona homeowners from losing their primary residence to certain creditors. These statutes allow individuals to claim a homestead exemption up to a specific dollar amount in their home's equity, safeguarding them from most unsecured debts. The protection applies automatically when the property is occupied as a primary residence and helps prevent homelessness due to financial hardship. The Statute of Frauds, ARS, PRO 44-101, requires that specific types of contracts be in writing to be enforceable. This law ensures clarity and prevents fraud in real estate transactions. Under ARS, PRO 44-1016, leases lasting 1 year or more and purchase contracts for real estate must be in writing and signed by the party to be charged. Additionally, ARS PRO 44-1017 mandates that agreements for broker or agent compensation, such as commission agreements, must also be in writing. This protects both clients and agents by ensuring that all parties clearly understand the terms of representation and payment. AAC R428-101A sets the foundation for professional conduct among Arizona real estate licensees. It requires honesty, fairness, and full disclosure in dealings with all parties. Licensees must protect and promote their clients' interests while also treating other parties honestly, reflecting the fiduciary duties owed in agency relationships. Fiduciary relationships arise through agency, where a real estate licensee acts on behalf of a client with duties of loyalty, confidentiality, obedience, and care. Agency can be created in several ways. Implied agency, as established in Hayward Lumber and Inverse Coy vs. Graham, 1968, may arise through conduct that demonstrates mutual consent, even without a written agreement. However, Walter V. Moore, 1985, clarified that implied agency cannot exist if the parties' actions do not clearly show intent to form such a relationship, protecting both consumers and licensees from unintended obligations. Expressed agency occurs through a written employment agreement, as required by ARS PRO 32-2151.02. This statute mandates that all real estate employment agreements, whether for listings or buyer representation, must be in writing, signed by all parties, and include clear terms regarding compensation. Subsection D of this statute distinguishes between representation and compensation, explaining that receiving payment from a party does not automatically mean the licensee represents that party's interests. Under ARS PRO 32-2152, the Arizona Department of Real Estate, ADREAL, has no jurisdiction over commission disputes between licensees. Such disagreements must be resolved in civil court, ensuring that the department focuses on regulatory enforcement rather than private contractual issues. The case Aliface versus National Investment Companies, 1994, further emphasized that compensation from a party does not necessarily equal representation. A licensee may receive payment from a seller or buyer without that payment creating an agency relationship, as long as the relationship is clearly disclosed and agreed upon. Finally, AAC R428-1101F requires licensees to disclose in writing any compensation or benefit received from more than one party in a transaction. This ensures transparency and prevents conflicts of interest by making all parties aware of financial relationships that might influence the licensee's judgment.